Good morning, good afternoon, and good evening to everyone, depending upon where you're tuning in from. I am very excited to welcome you to the second Africa in the Moot Educational Series. Today we have a very special speaker for you, someone who I don't think needs an introduction, but someone who will be receiving an introduction anyway. Unlike him, however, I think I may need an introduction. So to briefly introduce myself, my name is Stefan Kröll, and I am one of the founders and one of the existing co-directors of Africa in the Moot. Before we start with the presentation, I want to briefly touch on two things, briefly tell you all about Africa in the Moot for those of you that are not aware of the program, and then briefly mention some of the housekeeping rules of this call. Beginning with Africa in the Moot, we are a small non-for-profit that is completely volunteer-based, and we're focused on doing one thing, which is supporting schools in sub-Saharan Africa to attend international moot competitions. And the moot we have been focused on is the Wilhelm C. Vis Moot. We're very proud to be supporting 21 universities from all over the continent of Africa. And our support ranges from a number of things, including educational series like this with some fantastic speakers, to supporting the teams with coaches, supporting the teams to attend our own pre-moot, the East Africa pre-moot in Kenya, and of course, to support our teams to attend one of the most phenomenal educational experiences, which is the Wilhelm C. Vis Moot in Austria. That's a little bit about Africa in the Moot. Now I want to briefly tell you about the housekeeping rules for this call so we don't waste any time and you hear the speaker you really want to listen to today. For this call, all cameras are off, all microphones are automatically off. The only ability that you have to participate, which we highly encourage you to take part in, is to ask questions via the YouTube chat. We welcome you to ask questions at any point in time. Please feel free to ask a question even in the middle of the presentation. We will store these questions, we will keep an eye on them, and at the very, very end of the presentation, we will ask all these questions to Professor Kröll at the very, very end of his presentation, which will be taking somewhere between 45 minutes to 1 hour. So without further ado, thank you so much for joining our call. I will pass it along to my co-moderator, Silke, to briefly introduce herself and introduce our speaker, who I am quite confident does not need an introduction. Silke, after you.
Good evening, everybody. My name is Silke Schusse. I am the Deputy Chair of the Education Committee of Africa in the Moot, and I'm also a research fellow at the University of Vienna. And as already mentioned, I have the immense pleasure of introducing a speaker who doesn't really need an introduction. Nevertheless, I'm going to give you one. Professor Dr. Stefan Kröll is not only a professor at Bucerius Law School in Hamburg, but he is also one of the directors of the Vis Moot and is the chairperson of the German Arbitration Institute. He has published in the field of international arbitration and sales law and has furthermore acted as an arbitrator in over 100 cases under many different arbitration rules, including arbitration with state parties, and is regularly listed as one of the most in-demand arbitrators in Germany. We are very excited to have you for our session today. Welcome.
So thank you very much for having me, and thank you very much also for the invitation to Africa in the Moot. I'm glad that you take me at a time when most people still like me. That means before procedural order number 2 is out, and some of the problems you have been investigating until now have changed. Let me shortly share my screen with you because I would like to explain a little bit first about the Vis Moot as such, and then talk a little bit about general principles in arbitration and their role in the Vis Moot. I assume that you can see my screen now, the slides. Is that correct? Because I don't see them on the screen.
We can't see them quite yet. See if the arbitration channel can just assist us to present those slides. There we go. Now they're popping out.
Here we go. Yeah. So when I do that, you have to keep in mind that I'm German, and Germans are not known for being very innovative, being very funny, So Germans usually start with what we would call an agenda, or what you would call in the Vis terminology, a roadmap. Yeah. So most of the coaches at the end of the year will not have avoided using the word roadmap, I think at least 100 times. So let me first talk about a little bit about the Vis Moot, and thereafter then I would like to talk about the principles associated with characteristics of arbitration, primary party autonomy and its limits, which may play a role in the case and the solution of the case. And second point I would like to discuss is a little bit the regulatory web and the enforcement of awards. So before I do that, let me start with first congratulating you. Congratulating you for several things. First of all, of having made the choice to participate. The majority of people I've met who have participated in the Moot found it very worthwhile. Some of them even have said that it was a life-changing experience, and I know at least of 10 couples which came out of the Moot and where Moot babies exist, from not directly at the Moot, but later, and you can be sure that we won't charge you for being a matchmaker there. Second, for having been selected to represent a university. Again, there are a lot of universities where you only have one or two persons applying for the positions. But there are other universities where you have a crowd of 40, 50 people trying to get into the team, and the selection process there is fairly demanding. But at any time you're representing, whether it's just two of you or whether you are part of a larger crowd, you're representing your university and you're representing your country. And for a lot of other students, that's the first contact with someone of your jurisdiction, and they take in the impression they get from you. And last but not least, thank you for having stayed on until now. Because at the beginning, first day, everyone reads through the problem, finds it very interesting, and then you start looking closer. And at the beginning, it may be frustrating. Maybe frustrating primarily if you're dealing with the arbitration part, because there are issues which are not familiar to you. So it will become much more familiar to you, and I can assure you at the end of the Vis, when you're in Vienna, you will know the case inside out. You will very well understand what the case is all about. You will understand the underlying principle of arbitration and of the CISG. And you will definitely have learned quite a lot. Because when we talk about the Vis, for us, it's primary educational event. It's organized a competition, but our prime focus is the education. And why it's organized a competition? Because the BBC once wrote that the Vis is a little bit like the Olympics of international contract law and international dispute resolution. And no one comes to the Olympic untrained. So that means due to the competition element, most of you go the extra mile, spend the extra hours in the library, read the extra book, and do other things you wouldn't do if it weren't a competition. But as I said, for us, it's primary the educational event which counts. And what are the objectives which naturally also influence the drafting of each year's case? First of all, we have 4 questions you should answer. However, just answering these 4 very limited questions would be fairly boring for you after a short period of time. So that what we try to do, or what I try to do with the case is always, I try to have problems which require an understanding beyond the specific legal problem. And there may be some issues which at the first sight look like a problem, but then turn out to be dead ends. And the underlying rationale is that you also look into those and are not limited to these 4 legal problems. Second, I always try to select a topical issue, both in relation to the product, but also in relation to the legal questions which arise. The product may be controversial. So for example, we had 2 or 3 years ago, we had palm oil, where different people have very different views on whether it's good or bad. And what we try to show you, there's usually 2 sides to the coin. So it's not only one-sided, you're destroying the forest, but also to another extent, it is the lifeblood of some of the jurisdictions where without that, people couldn't survive. And you try to find then a kind of compromise between the 2. Or this year we have green hydrogen, and green hydrogen is something which is crucial, at least from the present perspective, for the energy transition. So I want you to learn a little bit about green hydrogen, and I want you to familiarize yourself with the technique underlying it, because one thing which is always important, if you want to deal with a case properly, you have really to understand the underlying product, the underlying industry, and build your arguments on the basis of this understanding. One thing we very often forget as lawyers, dispute resolution, decisions taken in dispute resolution always have a financial background. And in the end, it's always a financial decision, whether you continue with an arbitration, whether you start an arbitration, or whether you perhaps move to a different means of dispute resolution. Second, I always try to make it as close to reality as possible. That means usually I've talked to people in the industry about the product. So the prices are roughly the prices you pay. This year it was quite interesting. The people I talked to gave me really different indications, and it showed that depending on what you do, you have major differences between the different techniques. And that's for me always a quite interesting part, because I learned quite a lot. And what happens has happened in the past, that either the MAA, the Moot Alumni Association, or the institution whose rules we use, the Finland Arbitration Institution this year, organizes a separate webinar using someone from the industry, which has given me either advice or someone from the industry they know, to discuss a little bit the technical and the economic backgrounds of that particular industry. And I strongly encourage you, if that is done, to participate in these events. Second, there are also often legal problems which are topical and which come from real case problems. So you will see some cases which look very familiar to your case. Problems which arise concerning the taking of evidence, problems which may arise concerning the interpretation of these multi-tier clauses. And these multi-tier clauses are a trend which we see more and more in arbitration or in dispute resolution, that people are not restricting themselves to one mechanism, but in particular in projects like the present one in our case, they are using the entire spectrum of dispute resolution. And I'm not telling you a secret. One of the issues concerning privileges, how can you use these type of evidence? There has been a recent report by the IBA task force on privileges in international arbitration. So it's a topical issue at present. And what we also try to do is we sometimes ask you questions about what your view is on a particular problem. And we will ask the questions 3 times in the course of the Vis Moot. And I strongly encourage you to please answer these questions, because they are for us also quite interesting to see how students develop ideas about certain problems, how that has been influenced by the position they have been taken, and how the general view of the younger generation towards certain legal problems in arbitration or CISG is. And last but not least, we take into account the competition element. So the case contains a lot of information and contains probably much more problems that you can handle either in your written submission or in your oral submissions. But most of you at the end of the Vis journey will have dealt with the case for 6 months in great detail. And to make, in particular, Vienna a little bit more interesting, that we can really see which teams are excellent and which are extraordinarily excellent. We have these many problems in there that the arbitrators in the end can select points which may not have been discussed in greater detail before, and where then the competition element plays a role in the elimination rounds, that those who can react best to these newer questions or to this uncharted territory a little bit, they make it to the next round then. So that also influenced drafting of the case. So if you have the impression, or if you struggle getting all problems you have into this one submission, that is deliberate. You are principal have to make certain choices, and that is also something which happens in real life, that arbitrators have only a certain capacity to read and to basically digest what you present them, and you have to make choices. Take the strong arguments, drop the weaker ones. But be prepared in an oral hearing if something comes up and you have the impression that the tribunal has an interest in a particular argument, then react to that. Last but not least, there is a social and networking element, and that is also very important for the Vis Moot. So at the early stage, you probably just network within your team, and it's very often very unsocial. Some of you will have heard already the Vis Moot song, where they sing about basically losing all other friends apart from your teammates. But Vienna and the pre-moots, where if ever you can, I would strongly encourage you to participate. They are social and networking events. And that is an important element of the Vis Moot. And that is one of the elements why we have decided to keep the Vis Moot in person and not turn it into an online competition. For us, in particular, in a world today where we have wars everywhere, the meeting of people from different jurisdictions, getting friends in different jurisdictions is so important that we decided we keep the Vis as a purely in-person event, even though it may preclude some teams from participating. There may be other pre-moots which are held online, where the teams can participate. But the social networking event, for us, it's crucial. So let's now, after that introduction about the Vis Moot, let's now come to the case. And though I'm not myself on Facebook or anywhere else, some of my assistants are, and every year there is a meme channel. And the meme channel sounds very much like one of the leading CISG commentators. It's not schlecht Dreamschwänzer, but it's schlecht Memeschwänzer. And one of my favorite memes from the last years was this drawing of a horse. And it shows a little bit the situation you have at the beginning of the Vis Moot. You have a CISG problem which deals with sales law. Everyone has probably heard sales law in its domestic setting. Everyone has some understanding of sales contract, maybe not of international contract. And you will very often see that in the early stages, that you just basically take your domestic law and apply it instead of applying the CISG. But the procedural issue, arbitration, is in most jurisdictions, in most university curricula, not part of the standard curriculum, at least not in the early stages. So for a lot of you, you have perhaps a sketchy idea what arbitration is. And so at the beginning, it may be much more difficult for you to understand the arbitration problem. But I can tell you from my own experience, arbitration is one of the most fun parts of your legal tradition and your legal career later on. So it's worth trying to make sure that the sketchy knowledge about arbitration at the end of the moot is a full-fledged knowledge about the principle of arbitration. And I can tell you that the majority of the good teams I see, at the end, they know much more about arbitration than a lot of the practitioners which appear in front of me when I sit as an arbitrator. So what is arbitration all about? Arbitration, we have defined that in a book from 2003 as a process in which the parties agree to refer their dispute to one or more neutral persons, arbitrators, in lieu of the court system for judicial determination with a binding effect. From pronunciation, you already heard that there are a number of elements there, and I will focus today on the agreement of the parties. Not so much on the other ones, but that you see that also we learn if there's ever a second edition of that book, the definition would be changed, and we would add with a binding effect constituting an enforceable title. And this addition is exactly due to the fact that we had a development which is mirrored in this year's case, that we have moved from arbitration as just being the only alternative to court litigation to a much more elaborate system of dispute resolution. Let's say 20 years ago, or it's now 30 years ago, when we wrote our book, when we talked about dispute resolution, you had people negotiating, and if the negotiation failed, they went to arbitration or they went to the courts, and if they were clever, they went to arbitration. That has changed. Now, there are much more different means of dispute resolution, and they're very often combined in this what we call multi-tiered dispute resolution clauses. Here in our clause, we have mediation, arbitration, the parties have been negotiating, but there are other ones: mini trial, early neutral evaluation, expert determination, dispute resolution board, ARP-MET, ARP, and probably I could populate that slides with 20 other means of dispute resolution. And the main distinction you have, some of them are consent-oriented. That means you need an agreement of the parties to resolve the dispute. Others are decision-oriented. And that has also reflected to some extent in the landscape of moot courts. In addition to the Vis Moot, there is a mediation moot using the Vis case as well. It's the CDRC. And I can strongly encourage you, if you have the time, to participate in that as well, or to participate in a comparable event. It was mentioned that I'm presently the chairman of the German Arbitration Institute, and we offer for the German teams at least a weekend seminar where we look at the Vis case and mediate it, so that the students get a feeling how the case they have arbitrated for the last 6 months would work in a mediation. And that is something which is maybe an eye-opener for you as well, because you realize that there is a value in mediation and that it may feel entirely different, but that you meet an entirely different approach to these methods of dispute resolution, while the preparation for mediation is largely the same as you have for an arbitration, perhaps even more extensive, because you have to think about alternatives to what they would call enlarge the cake. So to show you that this year's case is fairly practical, I'm referring to one of the cases probably some of you have found out by now, and that's the International Research Group versus Lufthansa Systems case. In that case, and it's a very facilitated description of that just to show you what the issues were there, we had Datamant agreeing to update the booking system of Thai Airways. They used their subcontractor Lufthansa International Research Group. There was a problem. Datamant went insolvent. And the issue was, how do we keep the contract alive with Thai Airways, and then at the same time ensure that Lufthansa and international research groups are paid. So in the end, they entered into a supplemental agreement. The supplemental agreement foresaw that the payment from Thai Airways would go directly to International Research Group, and International Research Group would pay Lufthansa. Lufthansa was unhappy with the payment and started arbitration. And the interesting part was that in the original contract between Lufthansa and Datamant, there was a dispute resolution clause. In the contract between Datamant and International Research Group, there was no such clause, no arbitration clause. And the supplemental agreement was also not entirely, did not contain a clause itself, but merely a reference to the other two agreements. So in the arbitration, International Research Group challenged the jurisdiction of the arbitrator, and the arbitrator, in a preliminary ruling, came to the conclusion that he had jurisdiction. The entire case came to the Singapore Court of Appeal in the end because International Research Group asked for setting aside of that preliminary ruling for lack of jurisdiction. And the arbitrator had to deal with the following clause: that disputes should be referred first to a committee consisting of the parties' contract person. That's the working level. Then, if they cannot agree, to the director-customer relations, so going a level higher. And last but not least, to the managing director level, the C level. And that was a clause coming from practice, which foresaw 3 levels of negotiation already at the beginning. Only when that was unsuccessful, they didn't go to mediation, but they then could go to arbitration. And why do I present that case? Because it shows how that clause in 2013 was interpreted. The arbitrator came to the conclusion that the clauses 1 to 3 foreseeing negotiations were not enforceable. They were agreements to agree and could not be enforced, and assumed jurisdiction, arguing that the clause from the agreement between Lufthansa and Datamant was included into the contract, the 3-party agreement, and therefore also bound International Research Group. The court at first instance came to a different conclusion. They came to the conclusion, no, these clauses 1 to 3 are binding. However, since there have been discussions between Lufthansa and Datamant, they were in principle, their purpose was fulfilled. And therefore, Lufthansa could go to arbitration immediately. By contrast, the Court of Appeal took a very strict approach and said, if they agree on a particular mechanism for dispute resolution, this mechanism is a condition precedent, the fulfillment of the mechanism. Yes, they have negotiated here, and they have negotiated for a long time, but not at these different levels. For that reason, the court declined jurisdiction. And there are a number of decisions, and I'm not saying whether it's a good or bad decision, which come to slightly different conclusion. It's not an issue of jurisdiction, it's an issue of admissibility, there's discretion of the tribunal, but it shows you some of the problems which may arise in connection with these multi-tier dispute resolution clauses. And it shows you that the companies which we would call dispute-wise, like Lufthansa Systems, like the persons like International Research Group, which deal with technologies where it's certain that you will end up with a dispute somewhere, that they very often now go for these multi-tier clauses. So let's take a step back and look again at the characteristics of arbitration. The main characteristics I would like to discuss with you is party autonomy. And party autonomy, and now we are referring back to the clause, also has to deal with the question of referral of the dispute. It's arbitration only takes place if the parties have agreed upon that. The default mechanism without agreement is always court proceedings. So only if the parties deliberately take a decision, we want to go to arbitration, will the tribunal have jurisdiction. But party autonomy also governs the structure of the proceedings and the applicable law, issues which may be relevant or are relevant in nearly every arbitration you have in practice. The second element was judicial determination. And with the judicial determination, there are a number of minimum requirements, and these minimum requirements at the same time may limit the party autonomy. So judicial determination means you're bound by the decision of a third party, and that's only possible if the proceedings protected your right to be heard, if both parties are treated equal and if the decision maker is neutral. So you see a conflict between two of the characteristics of arbitration: party autonomy, judicial determination. And last but not least, in lieu of the state courts, which means on the one hand, state courts, whenever someone brings an action despite an arbitration agreement, have to decline and deny jurisdiction, stay the proceedings whatsoever. And second, it means that the outcome of the arbitration is or must be equivalent to a judgment. No one would go to arbitration if at the end of the arbitration you wouldn't have a kind of guarantee of having a decision which is enforceable worldwide. And that's where the New York Convention comes in. And that's also something you take always into account as an arbitrator. You want to render an enforceable award. And whenever you have to deal with questions balancing party autonomy against other mandatory requirements, you take into account how will that affect the enforceability of my award at the end. So let's take an example again of the problems which may arise when you have to combine or basically find a solution between sometimes conflicting problems. This is an arbitration or dispute resolution clause found in a private-public partnership in Germany concerning the construction of several hospitals. The project was worth more than $1 billion, and the lawyers were very sophisticated. They, and that's a translation now into English, they set up this dispute resolution clause which foresaw a 5-member contract advisory board, which could have different functions, but which also had the function of deciding as an arbitral tribunal if no other means of dispute resolution was successful. And how was that advisory board composed? The employer and the contractor will both appoint 2 people, and they will nominate their CEO and a technical director or project director for the board. And then the chairperson was to be appointed by these other 4 arbitrators. And the clause went on for quite some time and dealt with particularities, very specific particularities of German arbitration law, which showed that the drafters of the clause really understood their business. And with that, it was clear that the last sentence, the parties may submit any dispute to the advisory board for binding decision, was in a particular context intended to mean this advisory board acts as an arbitral tribunal and at the end renders an award. That's what happened there. And when it happened, one of the parties tried to enforce the award. The other party tried to have the award set aside. And everyone involved was certain that this is arbitration. And they were surprised when the Supreme Court told them this is not arbitration. One of the characteristics, indispensable characteristics of arbitration, the neutrality of the decision maker, is not guaranteed. Here you have the CEO of a company sitting in an arbitral tribunal, and in principle, the CEO represents the company, so the CEO is judge in its own cause. And that conflict was solved by the German Supreme Court in a way that they said there is a minimum requirement. This is not arbitration. If you want to take the decisions yourself, you can call it whatever you want. It may be expert determination, but it's not arbitration. On the other hand, also to show you how parties can use their flexibility and use them also in a way which is enforceable in the end, let me show you another arbitration clause taken from an Indian case where the parties agreed to arbitration in India under the rules of the arbitration of the Indian Council of Arbitration. However, if they were unhappy with the result, they opted for a second arbitration in London under the rules of the International Chamber of Commerce. Very often, parties will tell you, arbitration, you have one bite at a cherry. Yes, that is the setup you will find in the law. However, arbitration is all about party autonomy. While the parties in the German example used their party autonomy but overstepped the boundaries, in this case, the Indian Supreme Court came to the conclusion the clause is perfectly valid. And that is something you also see sometimes in the Vis Moot, that to make the case mootable in a way, to make it manageable, the parties enter into agreements which you rarely find in practice. However, very often I at the end ask myself, why are they not making use of their party autonomy? Because sometimes the clauses, the solutions we have to find for the Vis Moot would make sense in practice, would perhaps help to solve the dispute in a more efficient way. And that is also something which I always tell my students: if arbitration is all about party autonomy, you will benefit from arbitration to the greatest extent possible if you use the party autonomy. If you really create a procedure with the tribunal, jointly with the tribunal, which fits the needs of that particular case and not the needs of the standard case, that is what you get in court proceedings. Arbitration is about party autonomy, and the procedure order number one for each arbitration should look different because it should take into account the particularities of that particular dispute. So, what are the basic principles of arbitration? As I said, party autonomy. Party autonomy is there for all details of the arbitration proceedings: the composition of the arbitral tribunal, the determination of the procedure, which claims and evidence is submitted, as well as the law applicable to the merits. So you will find here all the articles in the model law, and the law applicable to the merits is very often clear. But there may also be cases where the law applicable to the merits is unclear because the parties have not very well expressed, have either not made a choice of law at all or have not very well expressed their choice. And also because there may be different laws applicable depending on how you characterize a particular contract. Second, a basic principle of the model law is that there's a guarantee of a fair trial. Arbitrators must be independent, parties must be treated equal, and the right to be heard must be respected. And as I said before, there may be sometimes a conflict between the guarantee of a fair trial and the second principle of party autonomy. But there may also be conflicts between the guarantee of an efficient trial and the guarantee of the right to be heard. So because if problematic evidence is presented, you want to decide the case on the basis of the facts as they were. On the other hand, it may affect the procedural rights of the other party. So there is a balancing involved. And as a tribunal, you're always happy if the evidence which is presented in your cases is not affected by either privileges, contested privileges, or coming from breaches of confidentiality agreements. The third principle is limited judicial intervention. The judicial intervention in the model law is there primarily to support arbitration, and only in the second instance to supervise and guarantee the fairness of the proceedings. So, for example, challenge of arbitrators or in the end, challenge of the award. And the fourth principle is there's a guarantee of an efficient procedure, effective procedure. So the model law contains provisions which allow you to appoint the tribunal if the other party is not participating. There are substitute appointments, which allows you to continue with the arbitration if the obstructing party is not attending the hearing, which guarantees interim relief, efficient interim relief, if it's not sufficient to wait for the final outcome, which helps you taking evidence if the tribunal lacks necessary powers, if you have to get evidence from a third party, if witnesses would not appear voluntarily and you cannot draw negative inferences from that. And it also prevents an obstructive arbitrator from basically preventing the rendering of an award, because the arbitrator at that stage is overruled by the majority. One of the problems is always which law applies to these various questions. And this is the easy part because we are just looking at 3 different laws. And these 3 different laws, and we are now coming to the regulatory web, the second point I want to discuss. These 3 different laws have to be determined on the basis of conflict of law rules. But arbitrators are not courts. The conflict of law rules, which may be applicable for state courts, may be not suitable for arbitrators because they allocate powers to a state court. Under which circumstances may a German court apply a foreign law? And there are considerations of sovereignty which do not play a role in arbitration. But in arbitration, you have to distinguish at least three different systems. First, the law applicable to the merits. Here, most modern arbitration laws, including the ancestral model law, contain a special conflict of law rule, leaving it to the autonomy of the parties. As I said, sometimes parties have made a choice, but it's not clear. That has to be distinguished from the law governing the arbitration proceedings. And that's usually the law of the place of arbitration. And the law governing the arbitration proceedings is relevant for taking of evidence, appointment of tribunals, and other important issues of procedure. And in between the two, you will have the law governing the arbitration agreement. Most of you will have heard about the doctrine of separability, that the arbitration clause, even if it's included in a contract, is still considered to be a separate agreement, and as a separate agreement may be submitted to different law. And here, as I said, we're talking about the easy way. There are numerous different laws applicable to various elements of the arbitration agreement. But the one law you have to know is the law governing the arbitration agreement, its conclusion, its validity. And when we talk a little bit more about the law applicable to the arbitration proceedings, the law of the place of arbitration, there is a hierarchy in the various norms. And when we look at the hierarchy, with that hierarchy, in principle, you can solve every dispute arising in relation to which law governs the arbitration proceedings. When a dispute has been submitted to arbitration, it's the law of the place of arbitration which provides the boundaries for party autonomy. It regulates which disputes are arbitrable, it regulates the minimum requirements for a fair hearing, and within these boundaries, it leaves everything else to the parties. And the parties may deal with the issues, may deal with the questions either by regulating it individually in the arbitration agreement, or by including in the arbitration agreement a choice of particular arbitration rules. In the Vis Moot case, the rules of the Finland Arbitration Institute. And if they have not done so, there may be international arbitration practice or soft law which plays a role. And if there's nothing in the soft law, you may have to find recourse to the applicable arbitration law. So the applicable arbitration law, as the law of the place of arbitration, has two functions. On the one hand, it limits party autonomy. On the other hand, it provides the fallback rules if nothing has been regulated, either in the arbitration agreement individually, in the chosen arbitration rules, or in the soft law, very often specifying broad concepts such as independence of arbitrators or other issues in international arbitration. And last but not least, you have the New York Convention, which sits at the bottom of everything and guarantees that there is party autonomy in arbitration and that state courts have to respect it and respect the final result of that. So that is the last point I wanted to mention, the New York Convention. The New York Convention in principle contains in its Article 3 an obligation to recognize arbitral awards and enforce them under certain conditions, which are laid down in the following articles. You have Article 4, which contains certain procedural issues, and then you have Article 5, which contains a number of potential defenses against the enforcement of arbitral awards. And one which plays very often a role in the discussions is Article 5.1d. And 5.1d allows to resist enforcement of an award if either the composition of the arbitral authority was not in accordance with the agreement of the parties, or the arbitral procedure was not in accordance with the agreement of the parties. or if the parties have not made an agreement, was not in accordance with the law of the country where the arbitration took place, meaning the law of the place of arbitration, in our case, the Vis Moot Danubia. So that was just a very high-level overview of basic principles of arbitration. As I said, I hope that by the end of the Vis Moot, your original horse will look like Nijinsky. And Nijinsky was also had played a role in one of the former Vis cases. He was the legendary originator of the Vis problem when we used the Hong Kong International Arbitration Center's arbitration rules. And I'm very certain that at the end of April next year, this will be a representative of your knowledge in arbitration. So what is the relevance of the overview I've given you for the Moot? I cannot really tell you. I think you will know by now yourself already. And I'm happy to answer all other questions which are not related directly to the Vis, because that is what you should deal with. And there's one question which always comes up and which I would like to answer immediately. I always get the question, what do you have to do to be successful in the Vis Moot, and what do you have to do to be successful as an arbitrator? And there's one person which is in a much better position to give you that advice than I am. That's Vince Lombardi. I think the younger ones of you will not know who he is, but Stephen Fleischer, coming from the US, may know who he is. He was the legendary coach of the Green Bay Packers. And he said once, when he was asked what is the secret of his success, he said, there's one place success comes before work, is in the dictionary. And it's the only place. And that also applies to the Vis Moot, and that also applies to your career as an arbitrator. It involves a lot of work. However, I would suggest that you do that work while preparing for Vienna. And once you have done that, once you're in Vienna, you enjoy the time in Vienna. So that is my advice for you for the participation in the Vis Moot, and I'm happy to answer any questions you or the two other people moderating that event may have. Thank you very much for your attention.
Professor Kröll, first of all, thank you so very much for taking the time to speak to our entire community, for always being so supportive of Africa in the Moot. We have one comment in the chat that you may have missed, but it gave me a chuckle. Professor Kröll is like Santa Claus. He comes once a year, always bearing gifts. So we echo that sentiment and very much appreciate your time. So let me pass it along to Silke, who has received a couple questions individually. We also have a couple questions in the general chat, and she'll field a couple of them, but being very conscious of your time.
Okay, so the first question from the chat I can see is it common for the procedural law to not be the law of the seat, or is it extremely rare?
That is extremely rare. You have a number of the national laws which in principle prescribe mandatorily that whenever an arbitration is taking place in that particular jurisdiction, it must be under the law of that country, that jurisdiction. That's also in principle the territorial approach of the UNCITRAL model law. You nevertheless, within this framework provided by the local law, then as an arbitrator, or parties may say, okay, we want to apply as a kind of contractual rules the law of a different jurisdiction. I wouldn't do that. I would most of the time go with the law of the place of arbitration, select your place of arbitration in one of the jurisdictions which gives sufficient freedom, and then you're regulating everything yourself in the rules of in the supplemental rules applicable to that particular arbitration.
Thank you so much. Moving on to the next question, and this makes me very This makes me very nostalgic because my Vis Moot problem was also very conflict of law centered. And the question is, do you find it normal in practice for arbitration proceedings to spend significant time on questions related to conflict of laws?
I would hope that people would, or parties and their counsel would very often spend more time on that, because I'm sitting in so many arbitrations where the conflict of law presentation is an entire mess, and I would suggest whoever does international commercial arbitration should have a very good understanding of conflict of laws and also the differences between conflict of laws in arbitration and conflict of laws in state court proceedings, because the underlying considerations are often different ones. As I said before, in state court proceedings, you talk about under which circumstances may a state court judge exercising sovereign authority apply the law of a different state. In arbitration, you talk about under which circumstance maybe someone who has been selected by the parties is in principle, under which circumstance is he limited by the provisions of a particular law not to do what the parties have asked him or her to do. So under which circumstances are mandatory rules of a particular jurisdiction, and there the place of arbitration comes into mind at first, but may have no relevance for the case whatsoever, may mandatory rules be applicable. If the parties, for example, have agreed on the application of Swiss law, under which circumstances may European competition law nevertheless be applicable, though it's not applicable in Switzerland? So one advice I would also give, if you want to make a career in international arbitration, have a sound conflict of law background. And I'm not only saying that because I edited a book with Professor Ferrari on conflict of laws in arbitration. And when we made the selection of the topics included, and we had asked for suggestions, we had to kick out half of the suggestions because the book would have been just too thick. So we just give you in that book an overview of the problems which may arise. And one of the Vis Moot issues this year is also the question which, or at least two of them are conflict of law questions to some extent. I don't want to tell more.
Okay, moving to our next question. The Vis Moot is quite unique. You argue both sides of the problem. Is there anything or any preparation that you do for claimant that you would do differently for respondent? I don't know if that already is too much to ask of you.
It's excellent. And that's what I think, why I think that the Vis Moot is very good for any type of education for a lawyer. That you understand that there is always a second side to everything. It's very rare that there's just one side. And that helps you perhaps also to understand the arguments of another side also in society. That you see you can approach the same problem from different angles and still argue the case in a reasonable fashion. And it also helps you in practice. And there is one of the cases or one of the stories my wife always tells in her mediation classes is from a partner in I think it was an American law firm, who gave a case to his team and said, we only have a limited amount of time. The client just came in. Please write, our client is the claimant, please write the case for the claimant. And we only have 3 days of time, and basically everyone works 24 hours. And then after the 3 days, he said, oh, I'm sorry, our client is the respondent. But now you have thought the case through from the claimant side, and now you know what the claimant is going to argue. Now you're in a much better position to understand what the claimant will argue and basically draft a much better respondent's claim. And that is also what you do for the oral preparation. In principle, you try to anticipate the arguments from the other side, weaken them at the beginning, or react to them in a particular way. And I think that's a perfect training for making a good trial lawyer in the end, but also perfect training for being not too divisive in a society like ours.
One thing I really like about the Vis is that a lot of it is more than just about the Vis problem, and that you see that you can apply so much of it in real life after after having done the Vis. And I think that's something that is incredible to see. In the German case, would the outcome have been different if the parties explicitly stated that the method of dispute resolution was arbitration and they decided to have the two CEOs?
No, it wouldn't have been different. They said it was arbitration, and as I said, I only took very limited parts from that clause, and it was entirely clear that this was arbitration. The parties believed it was arbitration. Everyone involved, including the people deciding, believed they were acting as an arbitral tribunal. It was just only at the stage of the German Supreme Court, also the the Court of Appeal came to the conclusion this is arbitration. Only the Supreme Court came to the conclusion, no, this is not arbitration. There are certain mandatory requirements, and this one of the mandatory requirements is arbitration must be done by someone independent. And the CEO is just representing a company, and you could have taken a slightly different approach. You could have said, okay, if both parties appoint their CEO, so we have two people sitting there, which are the parties, and in the end, the decision is largely taken by the person in the middle, the presiding arbitrator. And that would be fair. Both had equal chances. But the German Supreme Court said, no, this is so important for us that we would not qualify that as arbitration. And the German Supreme Court is normally very friendly towards party autonomy. So there are a number of cases where they have gone very far, but here they saw the limits. There may be courts in other jurisdictions which have a slightly different approach. Say, no, the one person is sufficient. And that is what I also always try to teach to tell my students, is that the problems are everywhere the same. The basic principles are everywhere the same. But the way you weigh the various principles, how much leeway you give, may differ from jurisdiction to jurisdiction. And sometimes it also reflects a little bit on the society you're living in. How much party autonomy you want to give, how much trust do you have in the courts, and things like that. So very often the arbitration law and the way it's applied, it's a mirror of the society to some extent.
The next question would be, how influential would we let the substantial facts of the case be on the procedural aspect? Should we completely separate them and try our best not to let them connect to each other?
I would advise you not to do that. So in principle, the case also has a second element very often. I cannot tell you whether it's here the same, that you have to coordinate between procedure and substance, because you may argue the case procedure in one way and by that destroy your substantive case. And in practice, what you don't want to do, you want to win the case on the merits, but you also have to cross the procedural issue at a certain point in time. So you have to really balance it in a way that you say, okay, I take perhaps the approach here, which is a little bit weaker, but which does not destroy my case on the merits and vice versa. So there's a technical considerations which may not be as obvious in this case as it had been in some of the other cases previously, but there was a real issue. You're strong on the one side, but that means you're weak on the other, on the merits, and vice versa. So you should always argue on the facts. There are sufficient facts there, and there will be additional facts coming, which help you to argue the case and find arguments for the various positions. But you should argue on the facts as they are in the case. You probably all know the rules that if someone just invents facts, that is not acceptable.
I imagine that will make our students pretty anxious for PO2. The next question would be, how would you advise teams to approach the issue of jurisdiction in this year's problem?
With a lot of work, I would say. So do your research, and approach it the way you think best. And I'm pretty sure you find a very good solution.
Okay, there are two questions, or basically one question on the Lufthansa case you referenced, that being, if the court held that the 3-tier clause was enforceable, what would have been the effect? And would the tribunal not have jurisdiction anymore, or would they have simply been required to stay the proceedings pending compliance?
The court found that the clause was enforceable, unlike the arbitrator. So the arbitrator took the very old approach, this is an agreement to agree, which is not binding. But both instances found the arbitration or the negotiation clause to be enforceable. So in principle, a mandatory provision. The only question where they differed was, has it been complied with? And the Court of Appeal said, you have to comply it according really to the letter. And the first instance court said, as long as you fulfill the objective of the clause, that is sufficient. The jurisdictional part, I cannot answer. So that's with Santa Claus. He only brings very few presents. Yeah.
Okay, the next question would be, can you clarify how the CISG's provision on liability for damages would apply to this case?
I haven't even thought about that. Yeah, but again, I would skip that one here.
Yeah? Okay, and then how would the arbitrators balance the principle of good faith and fair dealing with the parties' contractual obligations?
That is always an issue which is to some extent influenced by the personality of the arbitrator. Yeah? And that's what I also try always to convey in my lectures. Probably one of the most important decisions you take as a party in an arbitration is selecting the arbitrator. Even if we have a harmonized law, let's take the IBA rules on taking of evidence, which provides for a limited document production. The question what limited means very much depends on whether you're an American lawyer used to broad discovery, or whether you're a German or Austrian lawyer where document production is really the absolute exception, limited to individual documents. And that is also what you think about good faith. Yeah, some people have a natural aversion towards the principle of good faith. Yeah, so a lot of our common law friends think good faith is what we have on Sunday in church, while we have an entire book on what good faith, what kind of obligations arise under the German civil code just from one provision that the contract has to be fulfilled in good faith. And that also applies to arbitrators. So it is also something which may be relevant for your presentation in Vienna, that some of the arbitrators are from a civil law jurisdiction, which are much more open to an argument in good faith than other arbitrators coming from a different jurisdiction. But that's real life. That is, again, real life. Yeah? You have to make a choice at one point in time, say, do I argue good faith or not? And hope that the arbitrator is buying into that. The only difference is in a real arbitration, you can select the arbitrators yourself. And you know at least that the arbitrator you have selected should be on one side of the good faith divide.
Oh, and another question, which is a very nice one. Which one among the issues this year do you like the most?
I like them all. It's a little bit, you spend so much time thinking about that, yeah, and you're also sometimes surprised what comes out of that, yeah. So I really, in the end, I wouldn't say which one I would like to argue. Yeah.
Okay, we have two final questions for you. One, what sets apart a truly compelling oral argument in the Vis Moot?
What's truly compelling argument? It is an argument which everyone understands. Yeah. So where everyone says, okay, that is the answer, and I understand why someone behaves, which is, if it can be, not too formalistic, and which is presented in a way that the arbitrators sitting there have the impression that in principle they're in a nice talk with someone trying to explain an issue, and it's not in a way aggressive, too aggressive, or in another way, but it's just a talk between the arbitrator and the counsel, in which the counsel explains in an easy way why the party behaved in a particular way and why that is the party who should win the case.
Okay, and the last question is, our students have been wondering how do you go about writing the problem? I don't know if you can speak about that without telling all your secrets, but I think our students are very interesting to hear about that.
Now, how do I write about the problem? Yeah. So today I read a case, for example, which will figure in one of the future problems. Yeah. So something quite interesting. You say, okay, that makes a good Vis problem. You can include it, manage it in a Vis case. Yeah. One of the problems of the Vis case is a lot of the interesting issues are not decided by a 3-member tribunal, are decided by an institution. The problem, once we have selected the rules, I normally approach the institution and say, is there anything in your rules which you consider to be unique, consider to be very interesting, or do you have any interesting case? And then very often they come with a case and say that would be something what we would like to have and then I try to build something around it with the experience you have from practice, from teaching. There's usually some idea you find. And that's also with a product. Sometimes they come with a product, say this is very peculiar for our jurisdiction. And when I find that interesting, I take that product. For example, when we had the Brazilian rules, CISG rules on, the issue was, do we take football or do we take aircraft industry? And it was a close call. In the end, we decided to take the aircraft industry, but all characters in the case were very well-known Brazilian footballers. And so Pele was there and others with other names. And when we took the aircraft industry, it was a little bit to show you how that particular industry, which has a very particular pattern of contracting, how that works and how they also deal with disputes. So that is the basic idea. And then I start usually at the beginning of the summer, I start drafting something. And then after some time, you look at it again and there's add something here, add something there, have a different email address, have problems here, problems there. And so it slowly grows. Unfortunately, it always grows until Thursday evening, shortly before everything is in. And my assistants already know that at the time there's a lot of proofreading to be done, because there are a lot of mistake things which I've changed over the summer, things which have not been removed and all that. And you will be surprised. The case has by that time been read by, I would say, my 3 assistants several times, by myself and by other people looking at it. And you still find problems, issues where I've changed things. So there were years when I took, for example, the birthday of my children. When they were younger, they enjoyed signing the letters and all that. And if you are spending so much time away drafting the problem, the family has to get involved. So they must like it as well. And then one of the witnesses was 14 years old only, because in the last moment I tried to change I wanted to have her in 1980 something, and my oldest daughter was born in 1999. So the first question was, how comes, is there a problem with child labor? One of the witnesses is underage. So that is these are the funny things then. We say, okay, you better should finalize the case a little bit earlier, then things like that would not happen.
Well, thank you so much for joining us today. I think the sheer number of questions show that there is a high interest in hearing you speak and in asking you questions. So I would love to thank you on behalf of Africa in the Moot for making the time for us today and speaking to our students. Thank you so much.
Thank you very much. And I thank Africa in the Moot for bringing the African teams to the Moot. That was always one of the issues we really had, or one of the things what we were looking for an improvement, because there were so few teams from Africa. That has changed with Africa in the Moot, and therefore I'm always happy to join you here. And probably you've seen that in the Kluwer blog when I had an interview there, I mentioned you as one of the big success stories of the Moot. Continue your work, and I'm looking forward to seeing you and your African teams in Vienna, or perhaps even in Hong Kong. I might this year be in Hong Kong as well, or at any other place. Enjoy the Vis, and I'm looking forward to your question. Keep them short and don't write too many of them.
Thanks so much, Professor Kröll. Have a great rest of your evening and look forward to our many clarifications incoming.